Court desk calls the cases of the People versus Bloom.
This case opens with immediate tension, and if you followed Judge Simpson's courtroom before, you already know this is the kind of hearing where everything can go sideways fast. We're dealing with defendant Jeffrey Bloom, a man at the center of multiple felony allegations, from assault to unlawful imprisonment to criminal sexual conduct under extremely disturbing circumstances. Even before testimony begins, the defense is already fighting an uphill battle, arguing their client hasn't been able to follow the proceedings because of jail conditions. But Judge Simpson doesn't pause for chaos. He presses forward, determined to keep this hearing under control. Throughout this video, pay attention to how each witness frames the events, because the emotional weight behind their words will shape how the court interprets intent, credibility, and danger. You'll notice patterns. Inconsistent statements, escalating violence, shifting narratives, and a defendant who appears uncooperative even during the remote hearings. And here's the twist. This hearing isn't just about one incident. It's about a chain of events involving multiple victims, each telling a piece of a much darker puzzle. Stick through this breakdown, because the deeper we go, the more shocking the connections become.
Your Honor, just for the record, I need to make a record. I'm very thankful that Your Honor gave me a few minutes to speak with my client. My client informs me he has not heard most of what's going on here. He respectfully asked that I ask the court to adjourn these matters so he can be present in the court. For the record.
I don't need a response, Mr. Reiser. I will just indicate I have stated my reasons why he's not being permitted into court. He has heard the proceedings. To the extent he has not heard the proceedings, it may be because of his behavior in the jail. That is not anybody's fault. And so I am not adjourning these proceedings.
Your Honor, I know you made your decision, but just to clarify a little bit, he's claiming that the person in the next cell or room is just continually screaming for what that's worth.
That may be his own voice he's hearing.
Okay.
But the deputies had indicated that this proceeding could be heard by Mr. Bloom. And so I believe that to be the case. And so we will continue. Any other things for the record, Mr. Kilowold?
No, that about covers it.
Okay, real good. All right, Mr. Reiser, call your next witness.
Alex, A-L-E-X, Phillips, B-H-I-L-L-I-P-S.
You may inquire.
Thank you, sir. Can you tell the court where it is that you're employed?
The Washington County Sheriff's Office.
And in what capacity?
Road Patrol Deputy.
And were you working on August 21st, 2022 in your capacity as a road patrol deputy?
I was.
And were you dispatched to, is it Boston's? Rosen's Way, apartment A1?
I was.
And what time did you receive that dispatch?
22:59 hours.
Is it 10:59 p.m.?
Yes, ma'am.
What was the nature of the dispatch?
I was initially called in as an assault. Delayed a little bit, suspect not no longer on scene.
And who, if anyone, did you make contact with when you got to the scene?
Tiffany Blaisdell and Marshall Brown.
And did you speak with both of them about what had occurred?
I did.
Okay. And what was Miss Blaisdell's demeanor?
Anytime a police officer describes a victim as horrified, frantic, very emotional, the courtroom atmosphere changes instantly. This line isn't just about tone. It's foundational for the prosecution. A victim's demeanor immediately following an alleged assault is often considered highly credible because it's less likely to be fabricated under stress. The officer also confirms visible injuries, swelling on both sides of the face, bruising, and what appears to be a scab or abrasion. In legal terms, that's objective evidence supporting the emotional testimony. But this raises an important question for viewers. When someone appears this injured and distraught, how does the defense challenge it? They usually have only two routes: argue that the injuries came from something else, or try to show inconsistencies in the victim's story. And as we'll see later, the defense tries exactly that through supplemental reports. This moment lays groundwork for several felonies: assault, strangulation, and criminal sexual conduct. The court is already piecing the night together through trauma, emotion, and physical evidence, a powerful trio in any prosecution.
Horrified, frantic, very emotional.
As she described what happened?
She did.
Okay. And did you see any injuries on or about her person?
Yeah, she had several.
Okay. And could you describe those over the court what they were?
She had A lot of swelling in the cheekbones on both sides of her face. I believe the left side of her face had a large fist-shaped bruise, what looked like a scab forming on the cheek as well. Bruise on one of her arms.
And based on your information that you obtained from Mr. Marshall and Ms. Blaisdell, had the assault just occurred, or was there a delay in the report?
There was a delay.
And approximately what time, based on your investigation?
Approximately $500 in the morning until approximately 1700 that evening.
And was the suspect on scene?
No.
And did you have information about who the suspect was?
Yes, she positive.
Your Honor, that's a hearsay statement.
I don't believe the identity of the suspect is hearsay.
Yeah, I
It's coming from the victim.
I understand that, but that would go to his state of mind as to what may be his next action, so I'm overruling the objection.
This is a subtle but important legal win for the prosecution. When the defense objects, arguing that the officer shouldn't testify about information affecting the suspect's state of mind, Judge Simpson overrides it because the defendant's intent is crucial in cases involving assault or sexual violence. Intent shapes the entire legal characterization of what happened. Was the defendant acting with aggression, with coercion, with awareness of causing harm? These distinctions determine whether charges remain misdemeanors or escalate into heavy felonies like CSC, criminal sexual conduct, and unlawful imprisonment. By allowing this testimony, the judge effectively gives the prosecution more space to demonstrate a consistent pattern. Escalating violence, refusal to stop, and awareness of consequences. From a viewer's perspective, this is where momentum starts shifting. Judge Simpson is making it clear he will not restrict relevant testimony, especially when it helps build a clearer narrative about the events leading up to the alleged assaults. The defense's objections aren't landing, and that imbalance will continue throughout the hearing.
Did you have information on the identity of the suspect?
I did.
And who was that?
Jeffrey Wayne Bloom.
And he was not on scene.
Correct.
And were you able to locate him that evening or the next morning hours of your shift?
I was not. My partners were.
And did you provide that information at briefing or to any other police officers?
I should have covered everything, yes.
Thank you. I don't have any other questions.
Cross-examination.
Just a couple questions, Your Honor. Officer Phillips, when you went there on the 21st, you discussed, you spoke with Ms. Blaisdell, correct?
Yes.
And you were one of the officers that took her aside, correct?
Yes.
And based on what she said, you wrote a report, correct?
Correct.
And I would like to show you. I just lost it. And you followed up with a supplemental report also, correct?
I did.
Officer, may I approach Your Honor? Witness?
Yes, you may.
Officer, these are just partial pages of your initial report and supplemental report, specifically this paragraph and then this paragraph. And it's my understanding each time you spoke with Ms. Blaisdell, correct?
Yes.
And is it fair to say she indicated how Marshall's on your initial report? She indicated that she witnessed that assault on Marshall.
I believe so, yes.
Is that what your initial report says, where I showed you?
This is one of the most revealing exchanges so far. The officer confirms that in the initial report, the witness claims she did see the assault, but 3 days later, in the supplemental report, she states she did not witness it. That contradiction is exactly the kind of thing defense attorneys live for. Inconsistent statements can undermine credibility, not because one version must be false, but because jurors struggle to trust a narrative that shifts. And when the stakes involve severe felonies, credibility becomes everything. However, the prosecution will counter by explaining why victims often change details over time. Trauma, fear, confusion, intimidation, or pressure from the defendant. In domestic assault and sexual violence cases, this pattern is common. Courts know this, prosecutors know this, and judges take it into account when weighing credibility. Still, this inconsistency opens a crack in the testimony, and the defense steps right into that crack, trying to widen it into something bigger. Viewer question: do you think inconsistent statements automatically damage a witness's credibility, or are they understandable under emotional stress?
On the last lines there,
Yes.
Okay, and then you were asked to go back 3 days later for a supplemental report, correct?
Correct.
And you also discussed the incident with Ms. Blaisdell, correct?
Correct.
And what if anything, based on your knowledge, let me back up. You wrote a supplemental report, correct?
Yes.
And that supplemental report, there's a page there. Would you read that one just to yourself, that paragraph on the supplemental report?
With her?
Yes, please, yes.
Okay.
And based on what you're reading, was there a discrepancy whether or not she witnessed the incident?
Yes.
In fact, is your supplemental report, is your belief that she did not witness the assault of Marshall, correct?
I'm gonna object to whatever this officer's belief is, and he can testify to.
This moment is critical. The attorney pushes the officer to clarify whether he ever believed the witness actually saw the assault occur. The judge steps in fast, shutting down any attempt to force the officer to speculate about belief rather than fact. That distinction matters in court. What the officer believes carries much less weight than what the witness actually said. The defense is trying to turn the officer into a credibility evaluator, but Judge Simpson blocks it immediately. Smart ruling. Credibility is for the judge or jury, not the responding officer. But even with the judge trimming the defense's questions, the damage is partially done. The jury will eventually hear that the witness flipped her account. Whether that's confusion or something more will become part of the courtroom battle. This is a classic example of how subtle defense strategies work. They don't need to destroy a witness, they just need to raise doubt. Sometimes one inconsistency can weigh heavier than several consistent facts.
Okay. Did she tell you that she witnessed the incident at first, and then the supplemental report she didn't witness the assault on Marshall? I'm sorry, I don't mean to confuse you. You spoke with Tiffany
I did.
initially.
Trying to phrase.
For that police report, the initial police report, she claimed Marshall was defending her, and that's how Marshall got his injuries. And 3 days later, you were asked to go back and write a supplemental report. And my belief, you spoke with Tiffany, and at that time, for that police report that you wrote, she stated she did not witness the assault on Marshall. Fair?
Yes.
For the police report.
Correct.
All right, thank you. I have no further questions. Ma'am?
Any redirect?
Excuse me.
Did you, Deputy Phillips, actually see the injury to Marshall's penis?
This exchange hits on one of the most graphic and disturbing parts of the case. Injuries to intimate areas are treated extremely seriously by courts because they tend to indicate force, coercion, and assault rather than accidental harm. The officer's testimony that the injury was photographed and admitted as evidence is significant. Photos speak louder than words in cases like this. Even though the officer did not personally witness the assault, physical evidence paired with victim testimony forms a powerful combination. Prosecutors rely heavily on this kind of corroboration, especially in sexual violence cases where much happens out of sight. Meanwhile, the defense is cautious. They avoid challenging the injury directly because doing so risks appearing insensitive or dismissive. Instead, they try to cast doubt on the narrative around it. That's a strategic move, but whether it succeeds depends on later testimony from the victims themselves. This moment reinforces just how serious the allegations are and how damaging the physical evidence is for Bloom's defense.
I did.
And that was photographed and admitted as Exhibit 10.
Correct.
In your information from your investigation, is the defendant Jeffrey Bloom caused that injury to Marshall's penis?
Correct.
No other questions.
Nothing further, Your Honor.
All right, you may step down. Thank you, sir. Call you
No
to.
further witnesses, Your Honor.
All right.
No witnesses, Your Honor.
We would move for bind over, Your Honor, for on the felony counts contained within the information. I believe that the testimony of Tiffany Blaisdell does support bind over on count one, that the defendant Jeffrey Bloom did engage in sexual penetration with Tiffany Blaisdell under circumstances involving the commission of another felony, to wit, the strangulation. Marshall Brown's testimony that we heard earlier in September does support bind over on count two, that Jeffrey Wayne Bloom did engage in sexual contact with another person, Marshall Brown, causing personal injury to Mr. Brown and using force or coercion to accomplish the sexual act. Mr. Brown described in detail the assault on himself, how he was humiliated by it, and the injury was documented to his penis. So I believe that that's supports binding on count 2. Count 3 is a lesser included of count 1, the criminal sexual conduct during the commission of a felony, that the defendant did engage in penetration with Tiffany Blaisdell using force or coercion to accomplish the sexual penetration. If the jury were to find that the penetration did not occur during the course of a felony, I would be asking that they that they would convict on count 3 that he engaged in sexual penetration with Tiffany Blaisdell using force or coercion.
Here, the prosecution lays out a detailed legal roadmap, and its intents. They're explaining that even if the court or jury rejects the most serious charge, CSC, during a felony, there are lower-tier charges waiting underneath that still involve sexual penetration using force or coercion. In legal strategy, this is known as charge stacking and lesser-included offenses. Prosecutors do this to ensure that if the main charge becomes difficult to prove, they still have viable alternatives that carry significant penalties. What's striking is how confidently the prosecution walks through each element, referencing earlier testimony as if building a tightly woven narrative. Tiffany's account supports strangulation. Marshall's testimony supports the assault and documented injury. Together, they form a multi-layered case that's hard for the defense to dismantle entirely. For the viewer, this is where you see the prosecution's strategy clearly. Even if one part of the story cracks, the structure as a whole remains strong. That's dangerous terrain for any defendant, especially one already struggling with credibility and behavior issues.
Furthermore, Tiffany Blaisdell's testimony supports the count 4 that he made an assault upon Tiffany Blaisdell by strangulation or suffocation. Her testimony supported that today, that he was actually, as I'm arguing this final, I'm going to actually ask that the language be included because he was punching her about the face. So that should actually be. This is the GBH.
Yes.
And it only reads by strangulation, and it should be that the defendant did make an assault upon Tiffany Blaisdell with the intent to do great bodily harm less than the crime of murder and or by strangulation or suffocation. So I would amend count 4 to read that with the intent to do great bodily harm less than the crime of murder and or by strangulation or suffocation.
All right, understood.
And likewise, the language on count 1, the criminal sexual conduct during the felony would be during the felony to wit assault with intent to do great bodily harm less than murder or by strangulation.
Understood.
And I believe Marshall Brown's testimony also supports find over on count 5. He was really specific in his testimony about how the defendant was strangling him and how he had a raspy voice after that.
This portion of testimony is powerful because it adds detail to the physical consequences of the alleged assault. When the officer describes Marshall having a raspy voice after the strangulation, that is an immediate red flag for courts. Medically, a raspy or hoarse voice can indicate trauma to the larynx or vocal cords, often consistent with hands or pressure applied to the neck. Strangulation is one of the most heavily weighted assault factors in modern law. It's not just a sign of violence, it's a predictor of future lethal behavior. That is why prosecutors push these details into the record. They show intent, control, and extreme aggression. What's significant here is how each piece of testimony corroborates another. Tiffany describes being punched and choked. Marshall describes being strangled. The officer describes the aftermath. This triangulation builds credibility across witnesses. The defense knows this is dangerous territory, so watch how they avoid challenging the physical symptoms directly. Instead, they try to reroute the conversation toward inconsistencies in statements or procedural issues. But physical symptoms rarely lie.
Unlawful imprisonment for counts 6 and 7, I believe that both the testimony of Tiffany Blaisdell and Marshall Brown, that they could not leave They believed it was a real gun that the defendant possessed, and they were restrained in the apartment and could not leave the apartment. So I believe for probable cause purposes, there is sufficient testimony from both of them to support a bind over on count 6 and 7. I would be moving to add count 8, an additional count of criminal sexual conduct in the first degree. Ms. Blaisdell described 2 penetrations, penis to vagina, and then the forced oral penetration where the defendant was hitting her and putting his penis into her mouth. So there's an additional count 8 of CSC during a felony for the second penetration on Ms. Blaisdell, and count 9, the second penetration using force or coercion would be a CSC third that he engaged in sexual penetration with Tiffany Blaisdell using force or coercion. So count 1 would be the vaginal penetration, count 3 is the vaginal penetration, count 8 and 9 are the penis to mouth penetration.
Gotcha. Got it.
And we would ask that the matter be bound over to circuit court.
I'm sorry, can you explain count 9 again one more time? I'm trying to write this down.
Sure.
Yeah.
Count 1 is CSC
No,
1
no,
during.
count 9.
Count 9 is basically count 3 with the oral penetration.
Right, so count 9 is a CSC third force or coercion, penis to mouth.
Your Honor,
Yes.
at the probable
Response.
cause standard, I will leave it at the court's discretion. The brief time I had to speak with my client, he believed there was a lot of misinformation and frankly lies given by the victim in this matter, but for purposes of.
I thought he couldn't hear.
Pardon me?
Nothing. Go ahead.
No, it's true.
This moment shows the defense struggling against the judge's frustration. The attorney attempts to argue that his client couldn't hear the earlier proceedings, but the judge immediately shuts it down, noting that Bloom was, in fact, responding to participants. This exchange reveals a critical courtroom dynamic: credibility of the defense strategy. When a judge believes a defendant is exaggerating or manipulating circumstances, every later argument gets less traction. Bloom's earlier behavior in jail, yelling, causing disturbances, later even throwing toilet paper at the video tablet, undermines the defense's claim that communication issues are the real problem. From a legal standpoint, this matters because a defendant who is intentionally disruptive loses certain procedural advantages. Courts don't reward manufactured chaos. For narrative flow, this is the widening gap between defense strategy and judicial patience. And for viewers, it raises a key question. When a defendant behaves erratically, does it reflect guilt, stress, or personality? And should it affect how the court treats their arguments?
It's true. He would hear parts of it, Judge. So I'm gonna make sure
This is a part.
you can hear parts of it.
Okay.
But again, for purposes of exam, at the low standard of probable cause, I believe this court would has enough for a bind over in this matter. I don't necessarily agree with the counts 8 and 9, but Your Honor, I believe to the court's discretion.
The court, after listening to the testimony in this case and hearing the testimony of both Ms. Brown and Ms. Blaisdell, the court does believe that people have sustained their burden of showing by probable cause the offenses, and as amended as it regards the underlying felony as to count 1 and count 8, as well as to count 4 with its amendment, with its amended language to include harm to the individual less than the crime of murder. The court does believe that the people have sustained their burden on each and every count, including the requested added counts of 8 and 9 of CSC 1 and CSC 3, and therefore the defendant is bound over in this case to stand trial on all 9 counts.
Your Honor, for purposes of arraignment, waive the reading of the information, client to stand mute, you would ask for a trial date.
Defendant having waived formal reading as to all 9 counts, standing mute, court will enter a not guilty plea as to those counts. Pretrial will be set for.
This is the climax of the first major phase of the hearing. Being bound over means the judge has found probable cause to advance the case to trial on every single count, including the newly added charges. Probable cause is a low threshold. The question isn't, did he do it? But is there enough evidence that a reasonable person could believe he might have? Still, it's a devastating blow to the defense. Every charge survives. Every piece of testimony is deemed credible enough to proceed. Even the amendments, which elevated some counts, are accepted without hesitation. This tells you two things about Judge Simpson. He finds the witnesses credible. He sees a consistent, escalating pattern of violence. For the prosecution, this is a major win. For the defense, it means the battle becomes exponentially harder at trial, where standards rise and the defense must dismantle each count piece by piece.
November 17th at 1:30 with Judge O'Brien.
November 17th, 2022, 1:30, Judge O'Brien. In that case, the defendant's bond will continue as denied.
And I will present a new felony information to counsel and to the court prior to the pre-trial hearing.
Very good. All right, are we ready on the next matter?
Yes, sir.
Specifically, the court does call the case of People versus Jeffrey Wayne Bloom, 22 FB 1276.
Good evening, Your Honor. Amy Reiser, being on behalf of the people.
Hold on one moment. I lost the jail.
Jeffrey,
Hold it. The jail's off. They need to log back in. They thought we might be done. Yeah, they may not have. You let them know.
Unmuted. Ask who? There's no one there.
Yes, sir.
How do I ask? I don't know. The judge isn't there. I don't see anybody.
You're trained to ask.
Hello? Hello?
You may be seated.
Hello?
The court,
Muted you.
the court has called the case of the People versus Jeffrey Bloom, that being case 22 FB 1276. Counsel, state your appearances.
Amy Reiser on behalf of the people.
good evening, Your Honor. Robert G. Poole on behalf of Jeffrey Bloom. And Your Honor, just for the record, I would like to incorporate all the objections I made about my client not being here on case 22 FB 1278 FY into 22 FB 1276 FY, Your Honor.
And the court will incorporate its rulings into that, and the defendant will remain where he is.
Thank you, Your Honor.
Mr. Reiser, this is a date, time for preliminary examination. You may proceed.
People have contacted Charter Hill about.
Your Honor, if the other deputy is also going to testify, I ask that he be sequestered, Your Honor.
Deputy Rob is the officer in charge, so he'll be seated to my left.
All right, then the officer in charge may remain in the room.
Sorry.
It's late.
You solemnly swear or affirm that the testimony about to tell you the truth, the whole truth, and nothing but the truth, so help you God. See,
Thank you, sir. Can you tell the court where it is that you're employed
The Washington County Sheriff's Office
and in what capacity?
as a deputy sheriff.
And were you working in your capacity as a deputy sheriff on August 22nd, 2022?
I was.
And were you dispatched to Rosen's Way, apartment A1?
Yes.
And is that located in Ypsilanti Township, Washington County?
Yes.
And approximately what time did you receive the dispatch?
Approximately 6:32 p.m.
And what was the nature of the dispatch?
Can't recall exactly how many calls it was, but I know there was at least one call for subject on the porch of that address saying that we were looking for him, for the guy that was there.
And did you have an identity of the suspect when you responded that you were looking for?
Yes, we were looking for Jeffrey.
And did you have information about Mr. Bloom?
During briefing for the day, the night shift that was coming off advised that they had established probable cause for arrest for Jeffrey Bloom for kidnapping, criminal sexual conduct first, criminal sexual conduct second.
And are you familiar with what Mr. Bloom looks like?
Yes.
And can you tell the court how you were dressed when you proceeded to the scene?
I was dressed just like I am today in my full Class B uniform.
And were you driving a police vehicle
I was driving a marked police vehicle.
with lights?
likely firing.
And what happened when you arrived at 502 by Boston's Way?
I angled my patrol vehicle towards the porch of 5025 Boston's Way, apartment 81.
Now we transition into the second case, involving resisting and obstructing officers. The officer describes his approach: vehicle angled toward the porch, identifying two individuals, one of them Bloom. This kind of detail matters because it shows tactical awareness. Officers must be able to justify every action in a resisting case, and the positioning of the patrol car explains both visibility and officer safety decisions. When Bloom stands and refuses to step forward, that becomes the first indicator of resistance. Legally, resisting isn't just fighting or running. It includes failing to obey lawful commands. What's compelling is how consistent the officers' accounts are. Both describe Bloom taking an offensive stance, hiding a hand behind his back, and making statements like "watch this," which escalate perceived threat levels. In resisting cases, courts focus heavily on the reasonableness of the officer's response, and so far, the officers are painting a picture of a man preparing to escalate the confrontation.
I could see two subjects sitting on the porch. I activated my lights, which activated my body camera and infrared video. I started approaching, and I noticed one subject sitting there who we later identified as Marshall. I had not had contact with him prior. And next to him was Jeffrey.
You recognized Jeffrey Bloom?
Yes.
Okay, and did you give him any orders or commands?
Yes.
What did you do or say?
I told him to stand up. I told him that he was under arrest, and I told him to come to us.
And did he follow those commands?
He did stand up. He would not come to us.
Okay, and when you say us, was there another officer on scene with you?
I had Deputy Brown.
And was he in police uniform?
He was.
And so how many times did you tell Mr. Bloom to come to us?
I can't recall exactly. It was several.
Okay, and did he ever do that?
No.
What did he do?
He stayed on the porch where he was.
And what did you do?
I continued to advance towards Jeff. Deputy Rao also did that. As we got closer to him, Jeff took an offensive stance, put his right arm behind his back, and started reaching for his waistband. Typically, the type of stance where somebody's reaching for a weapon. And then he would instigate the situation, inching his arm towards us and saying, "Watch this, watch this."
Did you believe that he may have a weapon? in his
I
waist?
did.
So what did you do?
I drew my firearm, I pointed it at him. I continued to give him verbal commands.
And did he follow those commands?
He did not.
And what happened next?
Deputy Rob deployed his taser, which struck Jeffrey, immobilized him, and we took him to custody.
Thank you, sir. I don't have any other questions for you this time.
Cross-examination.
Just very briefly, officer, you wrote a report on this matter, correct?
Correct.
And in your report, it says that, I also know Jeffrey to often confront police and be in possession of deadly weapons.
Yes.
Is that your statement? Or is that your police report?
That's from my own personal knowledge of Jeffrey.
And what deadly weapons have you known in the past that he had?
I know several instances where he's been in possession of knives, and he's had contact with the police.
And is that no guns?
I can't recall any specific instance with guns other than the one that was described to me during briefing, which they said he was in possession of a real looking gun.
Which turned out to be a BB gun.
Turned out to be a BB gun.
And how many, and you said you know him from having knives, and how many occasions would that have been?
I can't recall exactly. It's been at least two.
Two, okay. And you're saying that you were giving him commands and he was continuing to approach you?
He did not approach. He stood up and stood on the porch and took an offensive stance at us.
Did he say anything to you?
He was saying, watch this, as he looked at me, had his hand behind his back towards me.
This line, "watch this," changes everything. In police encounters, verbal cues matter as much as physical actions. A phrase like that, combined with an offensive stance and refusal to obey commands, signals imminent threat. Officers are trained to react quickly when someone reaches toward their waistband because it is statistically one of the most common movements before a weapon is produced. The officer's reaction, readiness to deploy a taser, is consistent with training. The defense tries to portray the act as excessive, but the officer's testimony builds a strong argument that the response was proportional to the perceived danger. What raises the stakes further is Bloom's known history of carrying knives and what other officers reported as possession of a realistic-looking gun. Even if the gun wasn't present this time, prior knowledge influences how officers assess danger in the moment. It's easy to debate decisions from the safety of a courtroom, but in real time, officers must make judgments in seconds. Engagement moment. If you were the officer and heard "watch this" while someone reached behind their back, what would you assume is about to happen?
Okay, and you took, obviously you took that as a threat?
I did.
Okay, and where was Deputy Rob in relationship to you?
Deputy Rob was off to my right-hand side.
And was it fair to say you were in close proximity to each other?
Yes, I can't say exactly how far away he was, but we were close.
What, and again, I mean, later the point, were you closer to Jeffrey than Officer Rob?
I'd say we were pretty close to the same distance.
And was it light out, dark out?
It was still light out.
So it's your belief, when, and the taser, what color is the taser?
The taser is yellow, the body of the taser.
Okay, yes, okay. And you were aware that it was pulled out at some point by Deputy Rob?
Yes.
And did Jeff react at any point? I know you had your gun pointed at him. Did he say anything once the taser was pulled out?
I believe he did. I don't recall exactly what it was that he said.
You think it was a threat?
I can't recall. I can't say for sure.
Okay. And at some point you tasered her, correct?
I did not.
I mean, Deputy Rob did.
Deputy Rob.
And how many times was it, I know he was tasered once, but are there barbs that are?
There are two taser probes that come out per deployment. Deputy Rob discharged one taser cartridge. So 2 probes fired, and 2 probes made contact with Jeffrey, which immobilized him.
And those probes went through, and what was Jeffrey wearing at the time?
From my recollection, it was a t-shirt and jeans. The probes, after Jeffrey fell to the ground, came out of his body.
And can you just tell where, if you recall, where was he hit with the probes?
To the best of my recollection, one was in the leg and one was in the torso area.
And as a result, he fell.
Yes, he fell to the ground.
Was there any more resistance after that?
Yes, it was.
And what resistance followed that?
We had to muscle Jeffrey's arms behind his back to put handcuffs on him.
And were the tasers still in him, or are the tasers, are the barbs, the probes taken out at first?
I can't say for certain at what point the probes came out. All I know is that once we got Jeffrey up after he was in cuffs, the barbs had fallen off.
Okay, and I'm assuming once he was in cuffs, no more problems with them?
That's correct.
And just one last one, did he appear intoxicated
I can't say for sure.
or under the influence, or did he mumble anything, or?
I don't know.
Okay, thank you, I have no further questions.
Any redirect?
No, no.
All right, thank you. You may step down.
The people will call Deputy Thomas Rob.
Sir, please come forward and be sworn. Okay, you may inquire.
Deputy Rob, can you tell the court where you're employed
Washington County Sheriff's Office,
and in what capacity?
road patrol deputy.
And were you working in that capacity on August 22nd of this year, 2022?
I was.
And were you dispatched to Bozen's Way, apartment A1?
Yeah.
And what was the nature of the dispatch?
We need to call him as a reporter of disorderly subject. It's also, I believe, the call screen also noted this is a follow-up because deputies have been out at that residence previously.
And were you looking for anyone in particular when you arrived at the scene?
Yes, we're looking for Jeffrey.
Excuse me.
Bless you.
And did you have a physical description, or did you know what he looked like?
I believe I had one prior contact with Mr. Bloom, and I also refreshed my memory with his Michigan Secretary of State driver's license photo.
On your way to the scene.
On the way to the scene.
And tell us what happened when you arrived to the apartment.
I was following in my own fully marked patrol vehicle, behind Deputy Hillbuck's patrol vehicle. We both pulled into the complex, in front of the apartment. There's an open air patio to the apartment. Pulled up, I exited my patrol car, saw two subjects on the patio. Deputy Hillbuck and I approached the patio, recognized one of the subjects to be Mr. Bloom. Deputy Hillbuck, began telling Mr. Bloom he was under arrest, come over to us.
And did Mr. Bloom do that?
He stood up from his seat, I believe he was seated, and he stood up when he saw us arrive, but he remained on the patio.
And were you in your police uniform?
Yes, ma'am.
Okay. And at some point during that encounter, did you give Mr. Bloom commands?
I did. I let Deputy Hillbuck give the initial commands when we were approaching. Mr. Bloom stood up, took an aggressive stance toward us, started glaring and grimacing, or making those expressions on his face. When he stood up, he put his right hand behind his back, reaching towards his waistband. And since we had prior knowledge that he was known to be armed, and as per the last call for service, then we believe he had a firearm. We drew our service weapons. I told him to remove his hand from behind his back, that he was under arrest, and come over to us.
And did he do that? Okay. And did you specifically give him orders to remove his hand behind his back?
I did. I told him numerous times to show us.
And did he do that? And what happened?
Some other deputies were also right on scene. They had their firearms out, so I holstered my firearm and my taser. Armed it and pointed at Mr. Bloom. I gave him 3 more commands, with ample time for him to reply or respond. I told him to take his hands out from behind his back, or I was going to tase him. I told him that statement 3 times. He told him that before those 3 chances for opportunities. Then I gave him a warning, taser, and deployed my taser.
And what happened to Mr. Bloom?
It appeared that taser firearms struck Mr. Bloom, and he fell kind of sat down backwards.
And were you able to place him under arrest at that time?
Yes, we were.
And did he resist any further?
From what I recall, he was trying to pull his arms in, towards his chest, and deputies had to muscle and pull his arms back behind his back in order to get the blood.
After Mr. Bloom was secured in custody, did you make contact with any of the residents?
I went inside to check on the residents. I spoke with Mr. Brown and also with Ms. Blaisdell.
And what was Ms. Blaisdell's demeanor?
She appeared very agitated and frightened. I can see the injuries on her face from the previous incident that were noted in Deputy Phillips' report. Ms. Blaisdell stated that she
Your Honor, that's a hearsay statement.
You don't have to tell us. what
Thank you.
I don't have any other questions. Thank you,
Deputy Rob, just a couple questions. You ride by yourself in your own vehicle?
Correct. I was in my own vehicle, but I was driving behind.
And so was Deputy Hillbuck the first one to approach Mr. Bloom?
Well, it was fairly simultaneous. We both exited our patrol cars.
And you said he took an aggressive stance, and he glanced and he sneered at me, was that what you said?
Glared and grimaced, like maybe grimacing expression on his face, that it did not appear he was happy that we were making contact with him.
But he didn't say it, I mean, other than that, he didn't say anything.
Correct.
Okay. And he was given command to pull his arm back, correct, off his back.
Correct, to bring his arm out shows.
Okay. And at some point you said you holstered your weapon and you pulled out a taser.
Yes.
And did you say, I know what you said to Jeffrey, but how far away were you from Jeffrey when you tasered him?
Hard for me to say, but I had to guess 20 feet, maybe
Really?
25 feet. It's hard for me to guess without being there again.
I didn't know a taser goes that far, but
We had newly issued tasers that have a great range.
All right, and in your training for a taser, when you're going to taser somebody, is there a specific body part you go for?
You try to aim for pretty much not the heart area. Preferred taser deployment is on somebody's back, but it's not always available due to obviously exigent circumstances. So you try to aim for a lower portion of the body so you don't hit sensitive areas like the face.
Okay, and then once the probes hit him, he fell.
Correct. He kind of sat down backwards.
And then it's your testimony further that he was giving the officers a hard time to handcuff him.
Correct.
All right. And did he, during that time, was he making any threats to anybody?
I remember that he was saying something while we were trying to put him into custody, but I don't recall exactly what he said.
Okay. And then once he was handcuffed, was there any other obstruction or?
Not that I recall.
Okay. Did you take him to the police station?
Another deputy did.
And just as you approached them, I should back up a little bit, you did recognize Jeffrey as one of the people on the porch?
I did.
Okay. All right, thank you. I have no further questions.
Any redirect?
No, Your Honor.
Thank you, sir. You may step down.
Oh, I'm sorry, I did forget to ask Deputy Rob, I do have a question. You identified the defendant on the Zoom screen, the individual that you've seen on the Zoom screen.
Yes.
I believe he's there right at this moment, but is that Jeffrey Bloom who you've attempted to take into custody yet?
Yes, ma'am.
Thank you. I don't have any other questions.
Any questions based upon that? Mr. Cook? All right, thank you. And just before you make your argument or your motion, counsel should be aware that during Deputy Hillebuck's testimony, the door was closed to the cell because, and I don't know if you saw it at the time, Mr. Bloom took toilet paper, threw it out, trying to strike the tablet. So, but he is there and listening if he chooses. All right, go ahead, Ms.
Your Honor, we're moving for bind over on the two felony counts contained within the information. I believe that Deputy Rob and Deputy Hillebuck's testimony support bind over on an RNO that the defendant did assault, batter, wound, resist, obstruct, oppose, or endanger Deputy Thomas Robb, a police officer of the Washington County Sheriff's Office. That the defendant had reason to know was performing his duties, and that he did assault, batter, wound, resist, obstruct, oppose, or endanger Deputy Hillebuck, Trevor Hillebuck, a police officer of the Washington County Sheriff's Office, that the defendant knew or had reason to know was performing his or her duties.
Mr. Kilowog,
Your Honor, based on the probable cause standard, I'll leave it to the court's discretion. On this matter.
all right. And in this matter, the court having listened to the testimony, the court would find that the people have sustained their burden and of showing that the two counts of resisting and obstructing a police officer have been shown, one involving Deputy Hillebuck, the other involving Deputy Robb.
Your
And the court would bind the defendant over on counts 1 and 2. Yes.
For purpose of arraignment, Your Honor, we waive its reading. My client would stand mute. We ask for the November 17th pre-trial date.
Defendant having waived formal reading, standing mute. The court will enter a not guilty plea.
Commissioner, I have an information.
Sending it over to you now.
Is there a bond in this matter, Your Honor? No.
Not guilty plea. Court will enter a not guilty plea. Pretrial will be set for
November 17th at 1:30 with Judge O'Brien.
November 17th, 2022, 1:30 before Judge O'Brien. As to bond in this case, would you have a bond? I should have it on this form, but it's not there. Oh, yes. His bond in this is $50,000 cash as surety. Bond will continue in this manner. All right, folks, thank you very much.
Thank you, Your Honor. We have to take you from any nightly entertainment you might be doing tonight.
Like nice sleep. All right, no, you didn't get that far into the evening. All right, thank you, folks. Everybody have a good holiday and stay safe, please.
This hearing showcases two interconnected but distinct cases involving the same defendant. 1. A deeply disturbing series of allegations involving physical assault, sexual violence, strangulation, and unlawful imprisonment. The other, a resisting and obstructing case following Bloom's encounter with deputies. Across hours of testimony, the prosecution built a detailed narrative supported by physical injuries, emotional victim accounts, consistent officer reports, and legal structure through multiple charges and amendments. Judge Simpson ultimately bound the defendant over on all 9 counts, signaling that the evidence met the threshold of probable cause. This doesn't mean guilt is proven, but it means the court believes there is substantial evidence for a jury to evaluate. In the resisting case, officers' testimony showed escalating threat cues, commands ignored, and active resistance, leading the judge to bind those charges over as well. As the case heads toward trial, the credibility of witnesses, clarification of timelines, and examination of physical evidence will play major roles. Bloom's courtroom behavior, from refusing commands to disruptive actions during the hearing, may also influence how the court views future procedural requests. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.